Well, welcome back to Citizens Forum. This is segment 2, and we have with us today Calvin Cook from the Shawnigan Residents Association. I was going to say Shawnigan Lake Residents Association. Now, as everybody knows from what's been happening over the last couple of years, they're fighting what has become now a contaminated waste site in Shawnigan Lake. And there's been a lot of shenanigans that's taken place that have become quite a concern for the public, and there's much concern about the safety of our, not only the Shawnigan Lake water supply, but also the Souk Lake water supply. And Calvin is now involved in a court case in which they are. I'll let Calvin outline this court case so I don't get it wrong. So welcome, Calvin, to the show, and maybe if you can just give us an update of what's happening in court.
Yeah, thank you for the invitation. This week we started in Supreme Court. The court is in session on Burdett. It's room 401. It starts at 10 a.m. and I invite the public to come on down and view the proceedings. And really, what we're contending the court case is about, it's about two things. It's about trust, and it's about truth. And really the trust factor comes in that under the professional reliance model that's in place in BC, we have to be able to trust, the citizens of BC have to be able to trust our engineers who come up with the plans, whether it's a plan for a bridge, a hospital, a design, or in this case, it's a plan for a contaminated fill site. And they have to have that ability to communicate to the statutory decision maker that the evidence that they're providing is unbiased and it's to the best of their ability. And now our contention is that, and what we're going to the Supreme Court to prove, is that Active Earth, the engineering firm that supplied the science to the statutory decision maker that the Environmental Appeal Board made their decisions on, relied heavily upon that science, was biased in the fact that Active Earth had a 50% interest in this project, that their payment revolved exclusively around this permit being approved, and they shared in the outcome from this permit being approved.
Okay, so what is the basis of that? What evidence do you have that they actually had an agreement?
They had an agreement that was executed in February of 2013 that we've introduced as court documents that was signed by both parties saying that they were proceeding. Now the parties are saying that that agreement was never enacted upon, that they never proceeded past that point. And what we're introducing now is evidence that says that very much was still in effect, and companies were using that and proceeding on the premise that that was an active agreement. And that's what we're in front of the judge now to determine.
Now, is it, have they breached, it may mean that they certainly might have breached code of conduct, but have they actually broken the law?
Well, that's where the second part of our contention is that, and that's where it comes back to the truth. Now, our whole judicial system is based on hearing the truth. And our contention is that during those Environmental Appeal Board hearings, when they were asked about the relationship between Active Earth, the engineering firm, and South Island Argeggates, or Cobble Hill Holdings, we were told under direct cross-examination that it was just simple fee for service. This document came to light and it said that there was a partnership agreement. Our contention is that they actively concealed that evidence from the Environmental Appeal Board. We feel the Environmental Appeal Board would have made a significantly different decision had they been aware, had they been privy to all the facts that now have come to light. And that's where the truth comes in. Would they have reached that same conclusion if all of this evidence, and it was required to be, everybody was asked to produce and disclose relevant documents. Our contention is that these documents were actively concealed and were only brought to light in July of this year by a whistleblower who presented them. We still don't know who that was, but presented them to our office and said, a concerned citizen said, take a look at these documents. I think they're very relevant. And that then led to more documents being produced.
So those were the documents that you actually laid out. It was a copy of an agreement between Active Earth,
an executed signed agreement between,
and Cobble Hill Holdings.
Correct.
The two parties, the engineers as well as the owners of the landfill site.
Exactly. So we have several issues with that. One is that the science provided by Active Earth was heavily relied upon. The other issue, of course, is that oversight was being provided by Active Earth. Oversight on the project, so any compliance issues would be overseen by Active Earth. to us, that identifies a conflict. Any soils coming into that site have to be signed off by a qualified environmental professional. The QEP was from Active Earth. So from the residents of Shawnigan Lake, the Environmental Appeal Board conceded that the site wouldn't meet criteria, but the science, we could rely upon the science to protect us, to protect our watershed, to protect our drinking water, not only now, but for the future into perpetuity. And what we're finding out now is that the science can't be relied upon. The very biased nature of the science has to be called into question. Active Earth never testified at the Environmental Appeal Board hearings. They never stood on cross-examination. They were never qualified as expert, and yet their science was given an incredible amount of weight.
This is astonishing. And they were never called to testify.
Correct. They never testified during the Environmental Appeal Board hearings.
That is remarkable. Now, why is it that the provincial government, just to kind of get away a little bit from the case, because this is a very sound case that I think should be heard, but why is it that citizens have to take this route and go into court when obviously our government should just step in and say, okay, let's put the brakes on this, let's figure out what's gone on here, and let's not allow any more contaminated soil to be brought into the site?
Well, that's a viewpoint that we strongly feel. What we're really asking for is leadership. Leadership from our elected officials to represent the interests of their constituent, the best interest of the citizens of BC. We feel we've introduced enough evidence, and the evidence isn't being made from us, it's being given to us from materials that were delivered by the proponents. We're saying there's enough questions that surely our minister should step in and say, let's put a stay on this, let's prevent further contaminants from coming to that site. When the citizens of Shawnigan Lake win on this, that site will have to be cleaned up. The cost of that cleanup will be borne by all the citizens of BC, not just the citizens of Shawnigan Lake. It's incumbent upon our government to show leadership, to step up and say, enough is enough. Let's let the appeal go through. Let's put a stay on proceedings until all the evidence has been heard.
So look, it's 5 million tons proposed to go into
Correct.
the...
It's a 50-year project, 5 million tons. And what we're encouraging people to do is view our website. Take a look at the esra.ca, view the documents there, the archive documents. Come down to the proceedings. Listen for yourself. Get an understanding of what we're proposing and why we feel the injustice has occurred.
I think the public doesn't understand, like 5 million tons. How many truckloads is that? Do you have any idea?
Between the conversion, depending on what you want to use as a weight conversion, somewhere between 400,000 and 500,000 gravel truckloads of material. Not only a concern to the citizens of Shawnigan, but Souk Lake, the water drinking supply, the drinking supply for the citizens of Victoria is actually closer to the site. Now, there's no demonstrated evidence of connectivity, but we're saying there's no evidence clearly saying that they're not connected.
But it is elevation-wise above the elevation of Souk Lake.
It is, absolutely, and our concern would be is that in a seismic event, what happens in that case? They've occurred recently. No one can definitively say that contaminants from that site will not impact Souk Lake. There clearly is not enough science, and we're saying to our minister, given the risks, with so few benefits to so few people, step in, put a stay in place, prevent further contaminants from coming there and endangering not only the water supply of Shawnigan, but the water supply of the citizens of Victoria.
Now, have you heard anything from the CRD of Victoria on this issue?
Certainly, that is still in front of the Supreme Court. The judge is reserving his decision. We're not sure how long that decision will take.
Okay. Well, Calvin, it's an incredible story. I mean, it's so remarkable that we are in a situation like this where citizens are spending a heck of a lot of money and a heck of a lot of big part of their lives doing something that their government should be doing. It should be taking care of us.
Fighting the Ministry of Environment to protect clean drinking water. It's a little unbelievable, but it's happening today.
Well, we're going to have you back for sure, Calvin. It's wonderful that you updated us, and good luck with everything.
Thank you, sir.
Well, thanks a lot, and stay tuned for part 3 of Citizens Forum.